live streaming of the proceedings. We have agreed on case management number 1 that the remaining witnesses will adopt their written witness statements for purposes of the evidence in chief. So that when they come to the dock, they will just adopt that statement and will proceed straight to cross-examination. We have agreed that while that happens, the petitioner will make the decision on how many of the 22 witnesses they actually will need to call. And the consensus is that they will try to scale down on the number, of course, based on their best judgment, now that the main witness has given her evidence. We have also agreed that given the fatigue that everyone must have gone through so far, we would take the matter out of the hearing list for Friday. And even for today, that will give everyone an opportunity to refresh. They say a change is good, rather all work than no play. I don't know why they say they storm, they make a dull boy. Karanja has a serious penthouse in Naivasha, near Sopal Rocks, where we hope to unwind. We've also agreed that we could have further hearings on the 24th, 25th, and the 26th of this month. Those are the dates we've agreed upon by way of consent. Lastly, Your Honor, there are concerns that have been raised by the Nairobi Law Society.
You proceed on
24th, 25th, and 26th of September, the year 2019 AD. Lastly, Your Honor, there were concerns that had been raised about the decision of the parties to have this matter heard in public, and specifically having it streamed live on television. As the bar, we have reflected on the issue, and the decision we've agreed upon is one that balances the competing concerns. There was a consensus that if we absolutely shut out the media at this stage, there are those people who will ask legitimate questions. Then why has the media been suddenly shut out, having been allowed to cover the main part of the case? But we are also alive that there were people who were uneasy, even though it is not their case, with the live streaming of this matter. Of course, we want to reiterate, this was a decision of the parties, and nobody should be heard to attribute any wrongdoing to the court on how the matter was handled in public. It was a decision made by the parties. Anyone who is aggrieved by that decision should direct their anger and disappointment to the parties, not to the court. And the decision, we thought, reflects a compromise, but there shall be no live streaming of these proceedings. The media can record in court. When they go to produce their news bulletin or whatever, they can report on the matter, but there will be no live streaming. We know that decision achieves the compromise because it doesn't shut out the media, and it also accommodates the concerns of those who felt that having the matter streamed live breached certain established norms of handling this type of case. So that's the common position across the bar. Of course, we leave all these suggestions to the court and we'll take directions from the court accordingly.
I go to colleague. That is a decision arrived by both parties. The same way the parties are arrived at live stream of the media, the same way we have arrived at a position that live stream shall cease. We want to confirm and appreciate the role of the media, because it has been reporting very accurately. And Your Honor, you can attest that when I could not be able to get the cross-examination questions that were presented to my client, I simply went to the live recordings that were on YouTube. I got all the questions that my learned friend Udomi asked, and within 5 minutes, I was able to do the examination. That, Your Honor, we do appreciate that the judiciary is undergoing a transformational change. And among one of the pillars is the digitalization of the court processes. The media has assisted us at no pay to preserve the recordings, so that even if we lose or they lose,